Okay, Ms. Watson can be.
So I guess I'm going to argue for reconsideration and then for me to be removed. And
Sorry, we couldn't hear you. Why didn't you go to the podium? I
yeah,
know the
sure.
microphone can.
But I didn't think
There we go.
Should we switch seats? Do you mind if we switch seats? Or if you can sit there. Your Honor, I would, as far as moving forward, I would like to, I guess, argue for reconsideration on the contempt order on Ms. Tramel's behalf, and then argue the motion for withdrawal and for her to have new counsel appointed to move forward with this case, just based on our relationship.
All right. Tell me about the contempt reconsideration.
Yes, Your Honor. So there's a couple of issues. Number one, I have this was a communication issue between my office and Ms. Tramel. As you know, Your Honor, I did appear on August 8th. It was reset for August 10th. She was not here, as Your Honor is well aware. She was actually next door on reporting for jury duty as required. My office uses a software called My Case to communicate with our clients. I had communicated with her previously on there with Ms. Tramel via the text feature. I'm going through all this so you can understand why she didn't get noticed. On there, there's also a way for us to put court notices on there, which automatically sends notice to the client if they have an account. Unbeknownst to me, Ms. Tramel had never set up an account. We did check afterward, after all of this occurred. So fast forward to August 10th, I had 4 appearances that day, Your Honor. 3 were just very quick announcements on Zoom, and then 1 was an in-person and would not. And so I intended to, well, I thought it was virtual, Your Honor, but I did intend to appear on time. Unfortunately, that client didn't show up until 11:50 for a 9:30 a.m. calendar, so I was there a little bit later. During all of this, Ms. Tramel was going through something apparently, and my office was having difficulty reaching her. So by the time Ms. Tramel actually got notice, actual notice, it was about an hour shortly before I sent that email, Your Honor, honestly, about an hour or hour and a half before the appearance. Ms. Tramel was, I would argue, understandably upset at the situation. She said that she did not have the ability to appear in person on such notice. And she also did not have the ability to appear by Zoom. And so I went back and forth. I tried to get a new date, as Your Honor is aware, at the last moment. And it was denied by Your Honor. I continued to try to communicate with Ms. Tramel, and she was insistent that she could not appear. Your Honor, there have been several appearances in this matter, which Ms. Tramel has been here. I do not believe that her absence on the 10th was willful or intentional or a slight to the court. I don't believe that she meant to disrespect Your Honor or the court in any way. And she has been, she's obviously upset that she missed court. She did use her best effort. So that's the first thing, is the communication issue that happened and the breakdown. And since that, because of that, I think there's been a lack of trust from, between Ms. Tramel with respect to my ability to represent her. So I believe that it would be in her best interest to get new counsel appointed so that she can move forward and have counsel that she has confidence in. The second issue, Your Honor, is I'm appointed on this case. Ms. Tramel, we had, as part of the plea negotiations, it was a $300 fine. And we were talking about how, if there was a way to reduce that by way of community service because of her limited financial means. She is on food stamps. She only makes about $400 a month, and she just does not have the financial wherewithal to pay the fine. I'm sorry, Your Honor, that, there was a communication breakdown. I don't believe that she should be held in contempt for that, as it just wasn't a willful. She just did not have the means to get to court or to appear as required.
All right, Mr. Stevens. Oh, before you begin, did we ever retrieve the lease with the provision?
Mr. Stevens said that he was not reducing it even with the lease after reviewing the history.
Mr. Stevens?
Your Honor, it was the state's contempt charge, so a very brief response from the state. By Ms. Watson Cafe's own word is that the reason why she didn't receive notice is because Ms. Trammell was the one who failed to set up the account. Also, regardless of whether or not she received digital notice or notice from her attorney, I assume that the defendant would want to know what's happening with her case. So she should have inquired for when she needed to report to court. That being said, I was open to reducing the fine in exchange for community service. I'm always open to reducing the fine in exchange for community service. So I would ask that she still be held in contempt, but the state has no objection to reducing it from a $500 fine.
All right. Any rebuttal, Ms. Cafe?
Yes. Again, Your Honor, this isn't a situation where there were other means for her to get notice. This isn't a situation where the clerk, she normally gets notice, obviously through the mail, Your Honor, and because of the short time difference between Tuesday and Thursday, that wouldn't have been sufficient. So my office was the only way in which she would have been able to get notice. And again, it didn't happen until right before. Although we used our efforts, it just didn't happen until right before the appearance.
So, so far what I've heard is that the attorneys have done all the work. They have kept up with the notices. They have attempted, Ms. Watson Cafe has clearly zealously advocated for our client and attempted to communicate with their client. Mr. Stevens has done exactly what the state prosecutor attorney is supposed to do. Be prepared for trial, be prepared to take the plea, make the accommodations under the circumstances of the case. What I've not heard is any effort or any work or any thought on Ms. Trammell's case to assist in the defense of her case. She has not set up the appropriate portal to communicate with her attorney. She has not made an effort to have substantive conversations with her attorney. She has not made the effort to even bring a copy of the lease today or anything to that effect, which would indicate that she would be evicted if she were convicted of this particular offense. Instead, she shows up to court today, 35 minutes late, again, in complete defiance of the court's order, which required her to be in court in this courtroom at 1:30 p.m. Every single member in this courtroom made the effort to be here on time, except Ms. Trammell. She strolls into this room with her hat on, which is also a mark of rudeness in the court. None of my bailiffs are requiring her to remove her hat. But this is just another example of her defiance, her blatant rudeness to the court. I'm going to allow you to withdraw from this case, Ms. Watson Cafe, if that is your decision. The fine is going to be reduced to $150, or it will be a $1,000 signature bond through the jail, and she will turn herself into the Fulton County Jail today. Or she can reconsider the plea today. We can do the plea today, and it will be a conviction on her record. What would you like to do, Ms. Trammell?
First of all, I'm sorry, Your Honor, for the lateness of my tardiness today. I got late and sidetracked and inside the building trying to find this place. I do appreciate Ms. Watson and all the time that she did try to reach out to me during the time that I had my family emergency. So I wasn't able to at that time make it. I did not.
When was this family emergency?
It was the same day of the rescheduling on the 10th, 2 days after.
No, it wasn't. No, it wasn't. Don't lie to the court. I was here when your phone call came in, and I heard exactly what you said. So if you want to continue lying, that fine, that contempt fine is going to go back up to $500. Again, I'm going to ask you, you have three options. I'm going to let your attorney out of the case. You can decide whether you're going to jail today, or you're going to pay the $150 fine today, or you can consider the plea. What would you like to do? You have an attorney right now. She's still in the case. If you want to talk to her, you can step outside and talk to her. But you're not allowed to leave that corridor. Do you understand?
Yes, thank you.
Ms. Glanville will be on a brief recess. 5 minutes, Ms. Watson Cafe.
I wasn't talking.
Ms. Glanville, we can, okay, we are still recording. Yes, Ms. Watson Cafe.
She wants to do the fine, and she also wants to know if she can have 24 hours to 5 tomorrow to pay. The $150 fine, Your Honor.
Yeah.
Excuse me, when the cashier's office closes at 41, they start shutting down.
Okay, well, 4 tomorrow then, or 3:30 tomorrow. So we're not at the window when they're closing, Your Honor.
Okay. When's our next, file calendar?
Jury trial?
Mhm.
October or November is further notice as of right now. We don't have a
Dates, right? Okay. All right, the contempt order is modified to $150 fine. Miss Watson Cafe, I'm signing the order, withdrawing you from the case. That's been refiled.
Yes, Your Honor.
The fine is reduced to $150 payable by August 23rd by noon. By noon, otherwise a bench warrant will issue for Ms. Trammell with a $5,000 surety bond. And she will remain in jail until the case goes to trial.
Yes, Your Honor.
Any questions, Ms. Trammell?
No, thank you.
All right. If, please note that if the payment is not received by the clerk's office and confirmation is that it was deposited at 1 p.m. and not 12 noon, I'm issuing that bench warrant. I'm not tolerating any more misconduct on your part. No more delays, no more tactics on your part to avoid this trial. Do you understand? Yes. Your next court date is going to be sent to you in October, November. By then, you need to make sure you have your attorney. You can either go to the clerk's office and see if you can get another appointed counsel from the conflict defense, or you can hire your own attorney, or you can come to court and be prepared for trial. Not right now, you're representing yourself. I need to ask you, do you want a jury trial where you will have to understand the procedures on how to select jury in order to be prepared for trial, including the board process and so forth, qualifying jurors? Or would you like a bench trial where the jury is out of the equation and the case is tried before a judge?
A jury trial?
And why are you selecting a jury trial? I need to understand that you understood my question.
I don't.
Please stand up when you're addressing the court.
Yes, I just said the jury trial because I feel like that could be more helpful in my situation.
Okay. The trial is going to be scheduled either in October or November. You are responsible for making sure that you communicate with the court or that you get the court notices. The address that we have on file. I'm sorry, Debbie, what was it? The address we have in file is 171 Auburn Avenue, apartment 203. Is that correct?
Yes.
And the phone number ends with 4550. Your cell number?
No, that's my old number.
All right, so you've not updated us with your new number.
All right.
Is your home number ending in 5932?
Yes.
Okay. And is your email demetriat@gmail.com?
Yes.
All right. So we'll make sure that your phone number is updated, and that's the only notice you're going to get unless you make sure that you get appointed counsel or you go hire your attorney. Your attorney files an entry of appearance. Today is August 23rd. The entry of appearance must be filed August by September. I want to see the dates in September. Your attorney must file an appearance by September 8th. That's about just over 2 weeks.
Okay.
Get your attorney. If I don't care, if you want to hire an attorney late, that's entirely up to you. But I would hope that you do it by September 8th and the attorney files an appearance. Do you understand? That means filing with the court that he or she is your attorney. And that attorney must be ready for trial in either whatever the next trial date is. No more resets, no more continuances. Do you understand?
Yes.
Do you want another court appearance before your trial date?
Yes.
Right? Do we have a final plea challenge date?
We'll go with the October 6th, Your Honor.
All right. Your next court date is going to be October 6th. We're still going to give you a trial date, but October 6th is going to be a final plea calendar.
Okay.
You show up with your attorney and be prepared to take a plea unless your attorney has other things to discuss.
Okay.
Do you understand?
Yes.
That's going to be at 1:30, 9 a.m.
On a plea.
in person.
Correct.
You are not allowed to appear by Zoom since clearly Zoom doesn't work for you. All right? So quite a few things for you to do. Do you need to write it down or you're good to remember?
The,
I remember some.
To, clarify for the record, Your Honor, is at 1:30.
Is that 1:30?
Yes, Your Honor.
Okay, final plea, October 6th at 1:30. Jury trial will be in either late October or November. Entry of appearance by September 8th. And the $150 fine to be paid by August 23rd for 12 noon, Eastern Standard Time. I'm covering all bases. Do you have a question?
Thank you, Your Honor.
the bench warrant, Your Honor, that was issued.
I haven't issued a bench warrant.
Oh, yes, Your Honor.
I haven't issued a bench warrant. The bench warrant will be issued if that $150 fine is not paid by tomorrow.
Yes, Your Honor.
Mr. Stevens?
Your Honor, just for the record and for clarity, I just want to make it clear, is Ms. Trammell rejecting the state's offer today?
And if she does, what's the consequence?
The rejection, that the offer will be taken off the table and would no longer be to a plea to disorderly conduct, nor would be for the same terms.
Just for the record, so the state today is offering a reduction to disorderly conduct. And what are the conditions? How many hours community service?
So it's 12 months to serve 1 day,
Mhm.
credit for the time served, the remaining time balance probated, 60 hours of community service, and a $300 fine. And as Ms. Watson Cafe indicated earlier, I was open to decreasing the fine in exchange for increased community service.
All right. So if she decides to plead guilty to disorderly conduct instead of willful obstruction, it will be 12 months, serve 1 day, credit for time, serve 1 day, so no jail time.
No jail time, Your Honor.
And she'll be on probation to complete, if I convert the $300 fine to
Be additional
community
30
service,
hours.
then that will be 30 hours of community service plus the 60 hours of community service.
Yes, Your Honor.
And the court's assessment of the fine will be suspended. So that is the offer today. Do you have any questions about the offer?
No, Your Honor.
All right. So if you reject the offer in court today, this will be taken off the table. Would you like a moment to speak with your attorney? Oh, well, Ms. Watson Cafe, who's not her attorney, but
I'm more than welcome to speak with Ms. Trammell, or if she wants time to talk to Ms. Watson Cafe, to speak for a couple moments, but I will need to answer it today.
Okay, I'll speak to him.
speak to whom? Mr. Stevens?
Yes, for a second, please.
Step outside. All right, Mr. Glanville, we're on pause again. All right, we are still recording the proceeding. Ms. Trammell, now that you're representing yourself at present time, I have the duty to remind you that any decision that you make, any legal decision, you're responsible for how it impacts your situation, and that you're also responsible for understanding the legal laws and the procedures as it applies to your case. You also have a right to remain silent about the facts of the case. Anything that you choose to say about the facts, your statement can and will be used against you. You had a conference with the prosecutor, Mr. Jacob Stevens. What is your decision with regard to the options before you?
I'm gonna just take the plea. And I want to plead, I believe, no to it.
You may plead nolo if she qualifies,
That's what I'm checking right now, Your Honor.
and the court is also open to taking it under the first offender, and that may have a more positive impact upon any housing issue. If that helps. Is that something that the state is open to?
The state has no problem with her using her first offender. From what I'm aware, she may not want to use it today, given other charges that might be pending. The state has no objection to her using NOLO. She's eligible. The state has no objection to her using first offender.
It's entirely up to you if you want to use the first offender. I don't know whether that will have a positive impact upon your housing situation, but from what I gather, you may have other open cases against you, so you can either use it today or you can use it for your other case.
No, I just, no today.
Just no vote today?
Yes.
Okay. Do we have the plea paperwork?
Yes, Your Honor. I believe she already has some. If not, if it needs to be reviewed, I will give her the consent.
Has she gone over the questions, Ms. Watson Cafe?
I'll go over them with
Okay.
her.
All right, we'll be in a brief recess for Ms. Trammell to complete the plea paperwork. All right, Mr. Trammell, if you'd like to stand at the podium, please. This is State versus Lemitra Trammell, case number 19 CR 006-860, in which Mr. Trammell was originally charged with willful obstruction of law enforcement officer. Mr. Trammell, you've been advised of your right to remain silent. Your attorney in this particular case, Ms. Zakia Watson Cafe, has withdrawn from the case, and you have chosen to waive your right to counsel, and you're representing yourself. Would that be correct?
Yes.
And Mr. Trammell, you've read through the document with regards to your waiver of right of counsel. Did you understand that document?
Yes, Your Honor.
And do you agree to the waiver of those rights?
Yes, Your Honor.
And you've read through the waiver of rights with regards to entering a plea of nolo contendere
Yes, Your Honor.
to a reduced offense of disorderly conduct.
Yes, Your Honor.
And have you understood the statements in that document?
Yes, Your Honor.
Thank you. Mr. Mel, for purposes of the plea, may I place you under oath? You solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge.
Yes, sir.
All right. Mr. Jacob Stevens, what is the state's offer?
Yes, Your Honor. The state's offer in this case is to have Mr. Trammell plead nolo to disorderly conduct. The conditions to be 12 months to serve 1 day, credit for time served, remaining time balance probated, to do 60 hours of community service, and to have a $300 fine. That $300 fine, the state is open to reducing in exchange for increased community service. The state is also open to probation terminating upon completion of all terms. In terms of the facts and state, the basis, Your Honor, on the incident date, the police officer is called out to the location between a disputed man and a woman. The man pointed out Ms. Trammell. The officer then attempted to talk to Ms. Trammell. She ran inside a building. He followed afterward, attempted to simply speak with her. She proceeded for almost a period of 10 minutes to fight with the officer, kick at him, punch at him, and just in general refused to be detained. For those reasons, she was charged with willful obstruction of a police officer.
Thank you. Mr. Mel, in order for me to accept your nolo contendere plea and for this matter to move forward, you would have to agree that the factual basis as indicated by Mr. Stevens, that the location of the incident in Fulton County, Georgia, and that the identity of the perpetrator, which is you, are all true and correct. Do you agree with these elements?
Yes, Your Honor.
Have you consumed any medication or alcohol recently?
No, Your Honor.
And have you understood everything that's been going on so far?
Yes, Your Honor.
And is anyone forcing you or inducing you to take this plea today?
No, Your Honor.
Have you been represented by counsel until today? Have you been satisfied with the representation you received?
Yes, Your Honor.
And as we've already indicated, you've already gone over your waiver of rights. Just to understand, you're entering a plea of no contest to the reduced offense of disorderly conduct. Are you doing so freely, willingly, and knowingly?
Free. Yes, Your Honor.
Freely, willingly, and knowingly,
Yes, I am, Your Honor.
right? And just to understand the knowingly part, you know that you'll be waiving your right to a trial. You'll be waiving the right to have an opportunity to try this case in a court of law before a judge or a jury. You'll be waiving the right to challenge the evidence and the witnesses brought against you. You're waiving the right to present any defenses if you choose to do so, and waiving the right to have the state try to prove the charges against you beyond a reasonable doubt. Are you so waiving these rights?
Yes, Your Honor.
How do you plead to one count of disorderly conduct?
No.
I'll accept your plea of nolo contendere to this charge. Your sentence is 12 months to serve 1 day, credit for time served 1 day. The remainder of the time you will be on probation.
Mhm.
You will report to probation next week on Wednesday before 3 p.m. Understood?
Yes, Your Honor.
You must report to probation before 3 p.m. because that's the time they take in new probation clients, and they are also processing your case.
Yeah.
That you'll be out of there by 5 o'clock.
Okay.
Right? So it's next Wednesday. You will need to fill out the probation information, and it'll give you a copy. It's got the address and the phone number at the top.
Okay.
Marshall's providing you with a copy of that. I'll accept the amendment of the $300 fine to community service. So you have a total of 90 hours of community service to complete. That must be done by any nonprofit agency. And it cannot be a school and it cannot be a church. But you can go to any other volunteer nonprofit agency like Salvation Army, Goodwill, Animal Rescue, whichever one you're comfortable with, the food bank and so forth. All right? And you have all of 12 months to do that. But the sooner you complete your probation hour, your community service hours, the sooner you are done with probation. Because every month that you report to probation, you have to pay probation fees. You understand?
Yes.
All right. Upon completion of the 90 hours of community service, your probation will terminate. The sooner you're done, the less expensive it will be for you. In light of the court accepting this plea, the court is going to set aside and vacate the order of contempt. All right?
Yes, thank you, Your Honor.
Okay, so you need to fill out that information and give us back that copy.
Okay.
All right, Ms. Smith. Okay, Mr. Glanville, that concludes our case for the rest of the afternoon. Thank you very much.
Thank you, Your Honor. On the Zoom.